Dear partaker, our last topic will be the introduction to the remuneration and taxation of cost to the court process server in Tanzania mainland. This particular topic has its learning objectives or the learning outcomes, because the learning outcomes will make you to understand various meaning of the terms. For example, now we are talking of taxation. And we are also talking of the remuneration. There are two words, very confusing here. Taxation and remuneration. What should come first? To my understanding, the remuneration should come first. Because a court process server is performing the work, is sent by the court and regarded as a court bearer to go out and serve the documents. Now, what does he gain as a court process server? What does he gain at the end? Is he going to be paid? Is the court process server doing this on behalf of the court out of courtesy? Is it because he wishes to be part and parcel of the officers of the court, so there is no need for him to be remunerated? Of course, there comes an obligation for him to be paid, because even the judicial officers, we are being paid for the work done. So if we go to Oxford English Dictionary, it has simply defined the word remuneration as the payment of money made to the court process server or to any person for the work done. He has done the job. He has done the service of the process. He has served the summons, and the parties have appeared before the court. Now, what follows is for him to be remunerated, is for him to be paid the money. But under our legal framework, Rule 30, Sub-Rule 2 and 3 requires that any amount of money to be paid to the court process server must be taxed by the court. Now, there comes another requirement for the taxation. You see, we are talking of this money, the money which have been paid to the court process server, they must be taxed. They have to be taxed. The words become so confusing. You're talking of the taxation, now you're talking of the tax, the amount by the court as required under Rule 30, Sub-Rule 3, and Sub-Rule 2 of the court broker and process servers, appointment, remuneration, disciplinary rules of 2017. Now, because this money which a court process server has to be remunerated, there is a conditional precedent here that such an amount must be taxed. Who is to tax this amount of money? Our legal framework directs that the duty to tax, the taxation of cost filed by the court process server will be either the deputy registrar and the resident magistrate in charge according to the court levels. Deputy registrar, these are categories of bench officers that operate, who does business within the Court of Appeal and the High Court of Tanzania. Perhaps there are situations where the Deputy Registrar could be operating in the Resident Magistrate Court, but typically responsible to the directives of the High Court or to the Court of Appeal of Tanzania. So we are saying it is these two categories of officers who are responsible to make the taxation of the amount, the proper amount of money which is to be paid to the court processor. So the good information that I'm about to offer to you as a court processor in Tanzania, I am saying to you that you are not doing this, you are not doing the court process service free of charge. No, you will be paid. And one condition for you to be paid, to save the court document. The court document, we have seen the categories, all the types of the court document in topic number 1, that the court document could involve copies of judgment, could involve the copy of ruling, it could involve the summons, whichever the document. When it is served within the city, it has to be taxed 50,000. If it is out of the city, we are saying it is 50,000 plus the transport cost. So you make 50 plus other transportation costs that has made you to travel all the way to go and make the service out of the city. So these scales have been provided, and they are specifically provided under Part 5 of the Court Block and Court Process Servers Rules of 2017. Dear partaker, now the applications for the bill of cost according to various court levels in the judiciary of Tanzania is according to the specific forms. If you go to the third schedule, for example, of the Court of Appeal Rules of 2019, of course, currently they are rules for 2024. Formerly, they were Court of Appeal Rules of 2009, but of recent, they have been amended. Currently, they are to be referred to as the Court of Appeal Rules 2024 version. But if you are filing the application and maybe you are before the High Court or you are before the subordinate court, then Rule 55 of the Advocate's Remuneration Order will have to be considered for you to lodge such an application before the subordinate court. Therefore, I am saying all these for you to be aware that there are specific forms. And these forms must have the following contents. There must be particulars. There must be 5 columns with particulars. And these columns, there should be a number of items. We need to know what are the items. Are you charging for the service from point A to B? Then it has to be indicated. Then you have to tell us the particulars. What was it for? Then apart from that, you have to tell us the amount. The amount charged, it has to be indicated. And of course, the last column is for the court. Having heard the taxation proceedings, later on it should indicate in this particular item where you have indicated that you are supposed to be paid, say for example, 100,000. Then if the court has taxed 100,000 to be 70,000, then it should be indicated that it is only 70,000 out of 100,000 which has been taxed by the court. So those are the kind of columns that are supposed to be reflected in the forms. Now, having said this, in doing the taxation proceedings, in lodging the application for the bill of cost, there are principles to be followed. As a court process server, you want to be remunerated. Principle number 1 is reflected from Rule 30, Sub-Rule 3 of the Rules 2017, that it is until the court decides that this amount is what is supposed to be remunerated to the court process server. But another principle is the principle of reasonability. Reasonability is a situation whereby we consider the amount from all angles, that surely this is the amount which is supposed to be reasonably awarded by the court. And actually, this was emphasized in the case of Attorney General versus Amos Shiva. It is an unreported case, and it was emphasized that the amount taxed by the court should not be excessive. As a reasonable person, as a court process server, it will be very strange if we find that the taxation billing, the amount which has been applied exceeds even the decreed amount from the original case. So in all angles, we expect that the amount applied in the application for bill of cost should be very reasonable, and in all angles, it cannot exceed the original amount in the decree. But then another principle is the principle of necessity. There is a need that as long as you have incurred such an amount, we have given an example that if you are saving the document within the city, you have to be paid 50,000. But you see, you have gone to save, you have been paid 50,000, and you have not secured that particular person, and you have not been able to save. But let alone, the applicant has decided to apply for the substituted service. So it means there is some cost that could be reflected from the second service. There could be even the third service. So we don't expect in such scenario that you claim 50, but it could include the charges for other services, including if that area is not within the city. What if you have been told to go and serve in Kisarawe, for example, or you have been told to go and serve, say, for example, in Mkulanga, if you're talking of Dar es Salaam, that is another area of jurisdiction. It could involve some other inconveniences that could prompt you to claim an amount other than what you are entitled under the scale. So we are saying, as a matter of necessity principle, as a court, we consider that. Now, that said, would wish to conclude that the most impressive part, the most celebrated area by the court process servers, the most part which stands as a propeller, as a driving factor for a court process server to apply to be appointed, is the fact that is going to be remunerated. Therefore, it's a crucial part. It is the one which makes the reimbursement to the court process server. Dear partaker, having taken you through the remuneration process, I believe that you have been impressed. The fact that you are going to be paid, you are not performing, you are not doing the job free of charge. As long as you will be paid, I urge you, please make an application for you to be appointed as a court process server, for you to be part and parcel of the court, for you to be an integral part of the court. Together, we can make the performance of the court in an excellent manner. Thank you.